So I met with some of the highest lawyers in the government, and they said, ask me, what do you want in the end if you get your way? And I said, it's simple. I want you guys in jail. I don't want money. I want you guys in jail. Now, they knew I was serious because I already laid charges against government crown lawyers. I'll tell you, you can put the fear of God into any of them. Even though they know their buddies will protect them and cover up for them. The stigma of me being able to always stand up for the rest of my life and say Julian Fantino was criminally charged for threatening elected officials. And Chris Lewis was criminally charged for obstructing justice. And then I can name lawyers. It's powerful. And it changes judges' minds. When I first started doing this, judges thought I was a nut bar. Imagine. A citizen thinking that they have rights. A citizen actually thinking that they should go to the place where there's tire fires on the road, where the power station's been out for weeks, where people have to have passports to travel through town, and you think you should walk down the road with a Canadian flag? We all think we legal right, but are you crazy? So the OPP did a great job at painting me as the radical nut. It was easy. Judges believed them. 7 years has made a massive difference. I'll give you one ruling that actually can now be applied across Ontario. A Native woman tried to hit me with a pipe. That's good. No, it wasn't a peace pipe. I was walking on this subdivision that the government now owns, the government of Ontario. So it's deed titled to the government of Ontario. But it still has county roads through it. So we use the county roads, deed titled to the county. Okay, so the OPP, after arresting us numerous times for trespassing while walking down a road, and of course that didn't go very far in court, they finally let us walk down this road, because what else can you do? It's a county road. Right? It's like giving someone a trespassing ticket for driving down the 401. Right? You just can't do it. So anyways, this Native woman is screaming out telling the cops to shoot me. Right? And it was the first time in 6 years we met it inside the subdivision. Heck, police officers don't walk down the roads. They have abandoned the subdivision completely, by orders, by above. But this day, because we caught them off guard, we told them our rally was going to be at 2 o'clock. We started at 11 o'clock in the morning. So we were there before the OPP were ready. So we were already about 200 feet down the road, so the OPP had to run in and catch up to us. So this Native woman is screaming out, shoot him, use your guns. Right? He's trespassing. Right? Well, they're not listening to her. I mean, what could they do, right? I mean, the media's there. We always have our cameras running. So she goes over and picks up a pipe. It's from one of the light fixtures that were broken. And she tries to hit me with it. It actually was another Native guy who stopped her. Right? Well, the police arrested her on the spot, first time in 6 years. The Native person had been arrested during the commission of a crime. Police always arrest them weeks later, months later, sometimes years later, even though they're watching it. So you can imagine the commotion that caused. What do you mean? We're actually subject to law now all of a sudden? So she goes to trial. She doesn't hire a lawyer. Well, after swearing to the judge numerous times and telling him that she wants to fight him, bring it on, come on, let's fight. And after the legal defense of give me the death sentence, right? The judge tried to bend over backwards, because remember, she's self-represented. So in his ruling, he went through and said, I think she wants to argue this point, that she's a sovereign people and that they're not subject to criminal code. So he addressed that. I think she wants to argue this. I think she wants to argue that. I mean, he really bent over backwards to argue her defense, and she didn't put in any real words. But, if you're a judge of that courthouse, you've heard it all for 7 years. One of the defenses called color right. It's in the criminal code. The phrase is there. What it means is the following. Let's say you come home one night and you realize you locked yourself out of your home. And you decide, what the heck, I'm tired, I'm going to break the window, go in my house, and go to bed. And as you break the window and go inside, a cop drives by and sees you breaking into a house. Now, if he arrests you, what's your defense? I own the house. If I want to break the window, I can break the window. Right? You can't prosecute me for breaking my own property. Now let's change the story a bit. Let's say you come out of the mall and you realize you locked your keys in your car and you smash the window to get into the car. And just as you smash it, you look up and you realize, oops, my car's the next aisle over. I just smashed into a car that looks exactly the same, model, everything. Now, you probably would not be convicted on that for the same reason. Color of right is what you reasonably believed at that time that was your property and you were exercising it. You would still be subject to civil liability. So natives go around and say, because we believe you're on my property, because we believe we never turned it over to the state, because we believe it's our treaty, we believe we can use reasonable force to remove you, the trespasser, from our property. That's their argument. Because we believe we can use reasonable force to remove trespassers. Well, the judge came down with his ruling. He said she thinks she has color of right because she honestly believes that her people own this subdivision. And he said twice in the ruling, they cannot reasonably believe this. Why? Because Gary McHale and his group are challenging them. Color of right disappears if there's people opposing it. If you remain silent, you are consenting to the other person's rights. If you speak out, they have no reasonable expectation that it's their property. They can say all the words they want. From a legal concept of color of right, they lose it. So she was convicted because you can use force to remove trespasser. She couldn't use it because why? Because I was challenging her authority over the property. End of story. That can be used everywhere in Canada. A native person comes onto your property and says, is our treaty, is our property, you have the deed. Too bad. They don't have color of right, you do. That gives you full authority to do citizen's arrest and private prosecutions. It's your rights. Don't surrender them to the state. That's my presentation. Sure.
We have a few minutes for questions. If I can get somebody to take care of the microphone. First question is up here, gentleman in the red sweater. One moment, please. Please use the microphone so everybody can hear the question.
I understand the remark that charge Fantino. Was that upheld?
Well, what happens even in all criminal cases, the Crown is permitted to take over the case and drop it if they so choose. So, of course, what the McGuinty government would do through the Attorney General would immediately take over all private prosecution cases and drop the charge.
Okay, now in connection with, since he was charged,
Yes.
when he crosses into the U.S. and the customs officer asks him to be charged, he has to truthfully say he was.
You would have to say he was, but there would be no record of it. CPAC doesn't record charges, only records convictions. As far as reports, I should correct that, they do record.
I thought crossing the Challenger jet.
Heck, believe me, when they give me disclosure, everything I ever done, if I didn't wear a seatbelt, it's all there. They got everything on you. Someone phones up about a noise complaint, it's on your record.
What would you suggest doing with someone trespassing on your property and you arrest them? What do you do with them then?
You're required by law as soon as possible to turn the person over to the police. You're required by law. The Supreme Court has ruled that the only way you could do that is by giving you the right to use reasonable force to compel the person to go to the police station with you. Everything I do in Caledonia, we have multiple cameras running. Sometimes we actually wear pins in their cameras themselves. I would not do any of this without video camera. Your word against their word, it's too risky. I would do my best to let the police do their job. I really would. However, even under citizen's arrest, it actually says in the criminal code where it says you can do citizen's arrest where the availability of police are not there. Now, the OPP have never said that to me, because my response is, you're never there. Like, you're physically there, but you're never there. So that's my defense. I mean, appealing to the police. So my recommendation to everybody is first learn what your rights are, then tell the police you know your rights. I think it would go far further if the police would just do their job. They will do their job if they know in the end you'll do it for them.
I'm seeing so much corruption in this Ontario government with Wynne and the erasing of the emails and everything. Dalton McGuinness walked away, he's down in the States, yet it's corruption left, right, and center. Is there any way that we can do something to get these guys charged, especially Dalton McGuinness? Billions of dollars, gas plant cancellations, all this stuff, and they just walked away.
Well, there is. I mean, private prosecutions would allow you to lay a charge against anybody. You have to be able to identify the offense that you're claiming and have real evidence to show that particular evidence. The court works on evidence, not personal feelings, not political hatreds, on evidence. The problem you're going to have is the Crown's going to immediately get involved in the case, and the Attorney General of Ontario is not going to let you lay a charge against Kathleen Wynne. So in the end, what we really need, and I've recommended it in the book, and I've recommended it every time I speak, is the federal government needs to change the criminal code so that any time a public official is charged through private prosecution, it has to be prosecuted by a federal prosecutor. Every drug case in Canada is prosecuted by a federal prosecutor, which means the system's already there. So if you're laying a charge against the Commissioner of the OPP, then why should the Attorney General of Ontario decide whether or not to drop the charge on the Commissioner of the OPP? There's clear conflict. But until that is changed, the Attorney General can really do anything they want. So although we've used it a lot, and it's great for media attention and to expose the corruption, no one's been convicted on it inside the government because the government just will not allow a case to go forward. But I would still do it. I would still do it because it exposes what's going on. And you got to shame the government and you got to shame the police.
Two more questions.
I have a question. These situations you've been talking about, Gary, deal with criminal law. I'm just wondering if any of these strategies can be used in the situation of municipal bylaw, provincial regulation, or ministerial memos.
Yeah, the Private Prosecution Act inside the Criminal Code allows you to prosecute anybody that violates any federal statute, okay? So it's interesting that you can actually, you would technically be able to prosecute people on tax violations, environmental laws, anything that's a federal law you can prosecute on. On top of all that, there's a separate section in the Criminal Code that allows you to do summary offenses. And all bylaws and all building code laws are considered summary offenses. There are certain acts, like the Highway Traffic Act, that has an exemption clause in it that says can only be prosecuted by a private citizen with the consent of the Attorney General. I think it says with the consent of the police. So there are certain parts, like you can't actually lay a charge of terrorism against somebody because in the criminal code it says this charge cannot be filed unless by consent of the Attorney General. So even a police officer can't lay that charge. Hate crime, for example. No police officer in Canada can lay a charge on hate crime. It says right in the criminal code without the consent of the Attorney General. They have to get signed document from the Attorney General consenting to the charge. Nudity laws says right in the criminal code without the consent of the Attorney General, no charge can be filed. So you have there's a lot of power in this. You can enforce bylaws. You can enforce other laws on the books. But it's best to read the act you're trying to see and see if there's any provisions there that says you have to get consent from the Attorney General.
Last question.
Okay. I am very impressed by the ordinary Canadians changing our way of life and interpreting our laws to the benefit of the Canadian people. But I would like to ask you, you showed no sympathy at all for the fact that the police were trying to stop violence which would have happened if the natives had been allowed, or rather if they had arrested the native and it resulted in a death, for example, that happened in the case of Mike Harris and whoever it was killed. They were tried. But I know you did your part by turning it around, but what do you suggest we should do when we have violent groups that are willing to use violence?
Well, you know, the OPP have no problem raiding a biker gang. I mean, we don't say to violent groups, by the way, if you can prove to us that you're willing to use violence, we'll let you rob banks. We'll let you put officers in the hospital. We'll let you have people with brain damage. We don't say that to people, right? That's why we have the police force. You know, in the first Bill of Rights in the 1600s, you had the right to bear arms, okay? In Canada, we have advocated that to the police force. We've entered into a treaty whereby we, the citizens, give the government the responsibility to law and order. The government have breached their agreement. I don't carry arms. I let police officers do that. But if when there's an officer with a knife to his throat and anyone wants to argue, well, it might become violent. Too late, it's violent. All you're really saying is that the 60 officers that were in the hospital and the guy with brain damage, because they're not native, that's okay. Because not one native in Caledonia got hurt. That's not our standard of policing. If I decide to rob a bank and use a gun, and I get killed, I'm not going to be blaming the police for using force. And if natives are prepared to bear arms and brutalize citizens, had no say whatsoever in what happened, then I'm not going to cry the blues if the police have to use violence. That's what we expect. I don't want them to look at the color of my skin and say, oh, he's not carrying a baseball bat, so we'll let him be beat up because he's white guy. We did that in the South, in the States. We arrested black people because how dare they think they can walk through a white neighborhood? Or how dare they think they can ride on the bus in any seat they want? Or drink from the same fountain as a white person? Don't they know that the KKK will lynch them? Shouldn't they put themselves in a position where they accept their role in life and forfeit their rights? I will never give an inch to the police. It's unacceptable that we would even think we'd have to.
One last question, Gary. One last question.
Yes, hi, Gary. My name is Ade. I think it's Monica. We had a conversation. But this is regarding Kathleen Wynn's intimidation of TTC to breach a contract. Now, reading from section 423 of the Criminal Code, it says that if you without lawful authority, and the Metrolinx Act did not give her that authority, for the purpose of compelling another person to abstain from doing anything that he or she has a lawful right to do. The Metrolinx Act gave TTC that
only because we were discussing. This should be really a private conversation because now you're getting into detail of a particular case. What I would suggest to you is following. You quoted the section of the Criminal Code. The best thing to do is go on the internet, look up case law rulings about that criminal code. Every ruling will tell you what they call the essential elements of a charge. For example, what does it take to convict someone of an assault? Only two things. One, you applied some sort of pressure to the person. Two, he didn't give consent. You don't have to prove mental ability of crime. You don't have to prove anything. Only two elements. Every crime in the criminal code has what they call essential elements. You're referring to a particular crime. There will be a ruling that says you need to prove A, B, C. If you have the evidence for A, B, C, file the charge. It's straightforward and simple.
Thank you. Thank you.
Okay.
I'll do it.